Incredibly pleased to have him here. I don't think there's any living constitutional scholar who has had a more formative influence on my thinking about constitutional law, and so we're very pleased to welcome Professor Strauss.
Thank you very much, Andy. And I have to say it's a huge compliment to say that I had some influence on you. I told Andy at some point I wish he'd stop organizing things and get back to writing because I get so much out of his writing. You should spend 24 hours a day doing that and stop with this organizing. So anyway, thanks to all of you for coming. It's an honor to be able to spend some time with you. So my talk, I'm afraid it's not going to be especially optimistic, but that means optimism after you've been sitting in a room for 7 hours. You really want to be gloomy. So maybe I'll feed that. It has a title, it's Constitutional Law in the Age of Polarization. Let me give you the sort of what I see as the central claim, and then I'll try to elaborate on it. The claim is this. The foundations of modern constitutional law, by which I mean constitutional law since the mid-20th century, rested on a consensus within the legal elite. And that consensus was historically unusual, and it no longer, when it was no longer a key factor, constitutional law, which it now is not, constitutional law turned into a status competition in which groups seek constitutional protection as a sign that their victimhood is being appropriately recognized by the law and by society. And this kind of status competition among groups is especially destructive. It's a zero-sum game. It's an arms race. When someone else succeeds, you fail because they've been recognized and you haven't. It's also destructive because it doesn't go to material interests. It goes to things like self-respect, which in their nature, it's difficult to compromise or bargain for. So that's the basic idea. What political polarization, which has increased so greatly in the last couple of decades, what that's done is really to provide the vector by which this dysfunction spreads to the courts, including the Supreme Court, and spreads in a particularly virulent form as members of the legal elite identify with groups and see themselves implicitly as being spokespeople for certain groups in this status competition. So that's the basic idea. Now let me sort of explain some of that. When I said in the sort of consensus view of constitutional law, the foundational view, since the mid-20th century, what I have in mind is two things: the acceptance of the New Deal notion of the role of government regulating the economy, federal and state governments in regulating the economy, and the acceptance of Brown against Board of Education. So it's basically, in Tarzan and Jane syntax, Lochner bad, Brown good. That's constitutional law since the last 80 years. And Obergefell illustrated that, where Chief Justice Roberts' dissent said you're Lochnering. He picked up some criticism, which is its own story from people who thought he shouldn't be discrediting Lochner. And then you see the sort of recurring fights over who's the true heir of Brown against Board of Education and affirmative action cases. As an illustration of how these are the fixed points. Now, how do you reconcile those things? Of course, this was a big issue for that post-New Deal generation, which had come through the New Deal, come through the court packing fights, thought that the lesson of that era was courts should stay away from sensitive political issues, and they were confronted with Jim Crow and thought something had to be done about that. How do you reconcile the New Deal lessons with the need to attack this very divisive social issue? And the reconciliation, I'll sort of, just to give it a name, called the Caroline Products Reconciliation, whether the footnote itself embraces it or the problems with the footnote itself, I'm going to leave aside. But the idea is, yes, big, important, divisive social issues are to be reconciled through politics, except when some group is not getting a fair shake in politics. And if some group is not getting a fair shake in politics, they can call on the courts for protection. Or if there's some other dysfunction in politics. But as far as the civil rights movement was concerned, it was a group that wasn't getting a fair shake in politics. That was the justification for departing from the idea that divisive social issues should be settled by people who have to run for re-election. And the Caroline Products Reconciliation seemed to work. I mean, it seemed to make sense to say, look, I mean, okay, big issues about regulation of the economy, what promotes economic growth, foreign affairs, things like that, sure, that's for Congress and the President and the state legislatures, but you can't just turn over the plight of African Americans to the state legislatures in the South for obvious reasons, and that seemed to make sense. But that equilibrium, I want to suggest, was not stable because it depended on a weak consensus about the group that was being dispossessed and the group that needed special protection. And for the legal elite beginning really in the late 40s, into the 50s, in the 60s, and then certainly crystallizing by the late 60s, early 70s, for the legal elite, the idea that African Americans in the Jim Crow South were such a group, there was a solid consensus about that among the legal elite. Very little dissent from that proposition. But what happened was that consensus dissolved and was progressively replaced by competing legal elites that champion the causes of different groups. And that's the world we're in today. Now, in a sense, it's not that surprising, and maybe not even that new in American history, well, not that new in American history, that legal elites would be divided, and some would champion some causes and some others. But what polarization has done is to give this disagreement, not only to give it a sharper edge, and mean that people have less in common, but it's caused the elites that are the legal elite that's fragmented to split along partisan lines. And I think that is relatively new, or at least new in the last century or so, where the legal elite, some legal elites are associated with the Republican Party and see themselves implicitly or explicitly as defenders of certain groups, and ditto for the Democrats. And just not to pick on the Federalist Society, but I'm going to pick on the Federalist Society. The Federalist Society started out as not a particularly partisan group. It is now really acting as an adjunct of the Republican Party in putting judges on the courts in an open way. And, ACS, I speak as a former board member of ACS. ACS would actually be very happy to be able to do the same thing for the Democrats if they could. The reasons why they don't, that's a whole different story. So the result of this, I think, is that it becomes very difficult, both sort of for a couple different reasons. It becomes very difficult for judges whose legal careers have been identified with one party to break with that party's orthodoxy on an issue. So take the Affordable Care Act, the controversy about the constitutionality of the individual mandate under the Affordable Care Act. It became an item of orthodoxy on one side of the political spectrum that the individual mandate was unconstitutional. I actually think the legal arguments were borderline frivolous for that proposition. But it became accepted, and just to sort of, I don't think I'm being totally sort of partisan and polemical, if you look at the reaction of some kind of old line Republicans, people who were members of that old legal elite, they had the same reaction. They thought, people like Charles Fried, like, come on, that's not right. I mean, maybe it's bad policy, it's not unconstitutional. What are you talking about? But it became very difficult for Republican lawyers to take that position, and Chief Justice Roberts, when he sort of did take that position, was clearly putting himself at risk socially, politically, doesn't have to run for office, but putting himself at risk with people he hung out with. And to some extent, probably creating some internal cognitive dissonance because he was breaking with his team. And that's new, I think, that idea that now the legal elite is fragmented on these team lines, and it's very difficult to cross lines when your team is taking a position. I think that's new. And the way this was implicit in Caroline Products, and once you sort of build a test based on the idea, okay, who's getting not a fair shake in the political process, it is sort of predictable that you'll get this kind of division. What's happened and made it worse is the division's now become partisan, where it didn't, it wasn't relatively recently. So just sort of, let's say a little bit more about the sort of partisan nature of it. I mean, people, I don't know if anyone forgets, but it is the case that, Brown was a bipartisan decision. The Civil Rights Act was, of course, bipartisan. Roe versus Wade was very bipartisan. The Roe versus Wade court was the Nixon court. 3 of the 7 members of the Roe versus Wade majority, and not to flip the result, would have been appointed by Nixon. Nixon ran against the Warren Court. That was the most explicit campaign against the Supreme Court since FDR's time. He got 4 appointments. 3 of them voted for Roe against Wade. So whatever you think about Roe against Wade, it was a decidedly bipartisan decision at the time. Of course, that issue is no longer bipartisan. And this sort of playing out of this process in which the elites are divided, they all have allegiance to one party or another. The playing out of that process is what's recently happened in the confirmation process, the refusal to confirm Merrick Garland, the judge who would have been confirmed nearly unanimously in the relatively recent past because he was a Democratic appointee, but the kind of Democratic appointee Republicans could live with, just as some Republican presidents appointed Republican appointees that Democrats could live with. Merrick Garland was such an appointee. The fact that the Republican-controlled Senate refused to confirm it. The fact that in the aftermath of that, the president did not take a conciliatory gesture and appoint someone in the middle of the spectrum that, yes, a Republican appointee, but someone that Democrats could live with, but instead went as far to the right as he could and keep his coalition together. Then the abolition of the filibuster to end what was kind of a de facto supermajority rule, but there weren't always supermajorities for Supreme Court justice. All that is in line with this, and we now have a divided legal elite, and the different factions of the legal elite are affiliated with different parties. Some specifics about that as far as these competing claims to victimization. Gun owners. I think the litigation about gun rights is to a very large extent litigation about status, litigation about we want our rights recognized. That there are elitists out there who are disrespectful to us because we're gun owners. They think we're rubes. They think we're just kind of white trash, and we want it to be clear that we have rights. We have Second Amendment rights. Why else would they care about the gun ordinance in Washington, D.C. or Chicago, which are the two cases that are litigated? When the idea that gun rights are not protected in the political process in general seems fanciful. Gun owners do very well in the political process, at least to date. I would put white victims, quote unquote, of affirmative action on the same list. There's no real reason to think the political process is doing badly in handling affirmative action. It's a contentious issue. Some states have recommended disapproving it. There's a general reluctance to engage in it in a very aggressive way. It's hard to see why that issue is something that the courts need to intervene on. Religious groups, the issues there are usually statutory, not constitutional. They come up under RFRA. The RFRA is kind of a quasi-constitutional statute. A case like Hobby Lobby, which involved a group that had actually very successfully lobbied the Obama administration to create narrow the rules on the contraceptive mandate and to create exceptions to it. And despite that, really pretty considerable political success, still went to court to get even more success. And on the other side of the ledger, I would put the litigation about gay rights, where the Chief Justice in his dissent says, "Look, you're winning politically. Why are you doing this?" To the majority, the political winds are pretty strongly in favor of same-sex marriage. Why does the court need to intervene here? Now, a couple of things. Well, just to sort of crystallize that. Well, I'll say this. I mean, I'm not. The nature of the status competition, as I said, is an arms race. And so this morning there was some talk about unilateral disarmament, and I wouldn't want to criticize any group in particular for not backing down, because once this starts, the idea that, we will do it when the other side is doing it, it's hard to tell people that they should back down if they could do it, just because that's the nature of the competition. And then you are asking for unilateral disarmament. But it remains the case that a liberal justice on the Supreme Court, there's no chance a liberal justice on the Supreme Court would vote against same-sex marriage. Understanding all the Caroline Products arguments, if you had them, took them aside and said, the standard reasoning, this really is doing pretty well politically. This isn't kind of a case for judicial intervention. They might understand that perfectly. They would not vote against same-sex marriage. If I were a justice, I would not vote against same-sex marriage, even though I understand that. The weakness of the Caroline Products type argument. So that's the situation we're in, because then it looks like a unilaterally disarming. Okay, we're going to play by those rules, by the old rules where we don't use the courts just because we have the votes, but the other side is, and this dynamic is created, and it's a destructive dynamic. I think. Okay, if you say, well, why so destructive? I mean, we get there's some good things out of it, whichever side you're on, you can see some victories through this. Well, that's back to the Caroline Products issue. Why should courts be doing this? If these fights over status are going to be waged, why should they be waged in courts? There are lots of problems with that. You want, ideally, to have something that can be compromised. So the whole Caroline Products notion is, the groups, they'll fight it out as long as they have a seat at the table. With African Americans was they didn't, but if you have a seat at the table, you fight it out. Maybe you get half a loaf, 3/4 of a loaf, that's okay. You come back next time, maybe you'll get some more. When it's a status competition, you can't do that. There are winners and losers. Either you're recognized as a victimized group whose rights are being trampled on, and now the Constitution protects you, or you're not. And that's why defeat for same-sex marriage would have been demoralizing and seen as a blow to the status of gays, even though gays were succeeding politically. And ditto with the other examples I mentioned. There's really no reason to play these things out in courts. And the other thing that happens is that then the confirmation process, the process of picking judges, becomes intensely politicized, as we've seen, and very partisan. And now, instead of having people have to run for re-election every couple of years solving these things, the stakes are very high because you can get your group in power for a generation if you win this fight over the courts. And there's simply no good democratic reason for these issues to be solved that way, to be solved for a whole generation at a time. But once you have the situation in which courts can confer status on a group, groups want that status, do not want to back down. The legal elite divides on partisan lines, and one party can get its people in a position where they can implement their agenda. That's what you bring about. So, what's the solution? There is no solution. We're doomed. It's hopeless. I think the solution is a more modest role for the court. That's easy to say. Lots of people have said the court should play a more modest role. I have a couple more things to say along those lines. We actually have a model, a recent model for the court playing a modest role, and that was the time when there were 8 of them, and they were divided 4-4. There was a risk of dividing 4-4. They didn't really want to decide a lot of cases 4-4, because that would look like the court was not functioning well. So they really kind of worked things out. So there were a few 4-4s, but not that many 4-4s. And they really kind of worked things out in a way that they could agree on some outcomes. And the way they did it was by not being very aggressive, not being very venturesome, kind of keeping things low-key, deferring issues a lot, allowing some conflicts in the courts of appeals to persist, which may be something they should do more often, where it doesn't create insuperable practical difficulties. You could see it as a kind of federalism. So that's a possibility. Staying generally out of less inflammatory cases. I mean, one virtue of the current court is it really is composed of legal elites, at least in the sense that these are people who did very well on law school exams, which is all we care about. So in that sense, they're very able. I mean, there are obviously other dimensions that are arguably lacking on the court. So they actually can do quite well in cases that are not particularly high profile, not particularly politically salient, not particularly inflammatory, and maybe they should stick to those and spend a lot of their time on that, and they'll do well with that. How do we get here from there? Here's where I think the other branches can actually play a role. So what I have in mind is this. There's an argument which I think is Herbert Lexler's, about the exceptions and regulations clause of Article 3, the clause that confers appellate jurisdiction on the Supreme Court subject to such exceptions and regulations Congress may make. And the scope of that is unclear. It's not clear how far Congress can go or what exactly they can do in carving out exceptions. And obviously, they can do housekeeping type exceptions, but how substantive can the exceptions be? And the law is really unclear about that. And Wexler's idea was, well, it's good the law is unclear. It creates a kind of scorpions in a bottle equilibrium, where the political branches don't know how far they can go in cutting back on the court's jurisdiction before they can succeed, and the court doesn't know how aggressively it can push before the political branches might be able to curtail their power. So where I think that leaves us is the idea that a state of affairs in which The political branches are in a position where they're unhappy with the court, able to credibly threaten, seriously undermine the court's power by court backing or jurisdiction stripping, but don't do it, is the state of affairs we want. We want something where the court is worried about that happening, and so comes together, behaves as they did a little bit the way they did when there are only 8 of them. But if it happens, that'll just precipitate maybe another cycle in the status competition. One side does it, then the other side's going to do it, and we're just off to the races in a different arena, and we have a 75-member Supreme Court, and when all the packing gets done. So I can kind of see a little bit of light at the end of the tunnel, and I think it is really not out of the question. I think the recent events of the Kavanaugh confirmation and the level of hostility to the courts shown by the Democrats, I think there is a chance that will cause some people in the judiciary, maybe some members of the Supreme Court, to think, we need to pull back a little bit and pay attention to what's going on out there. We can still do our jobs very well without becoming players in a competition that in the end no one will win. So thank you for putting up with this.
Questions? Yes, all people.
Yeah.
So I think you left, I thought that was, I agree with you, except that I'm much less optimistic. But I think you left 2 related factors out. The first the larger factor is the idea of federalism. Right? It's imposing national solutions rather than allowing different groups to have different states to have different solutions to contentious problems. And that is related to what is one of the, when you said that the legal elites thought that Brown was rightly decided, not the legal elites of the South. What started this cycle, for good or for ill, and I'm repeating something I think I said earlier this morning, was so that we had up until 1850 and between 1890 and say 1950, that there was a consensus that people in the North would leave white Southerners alone, and that for good or for ill, Roland said he was in favor of slavery. No, that's not what I was saying. But the point is, it's very different. But so the sort of driving force, one of the driving forces behind what you're talking about was white Southerners picking up other groups to create a coalition, right? We still have the conflict, but that comes from the fact that they felt under siege from the north. So those are the only 2 things that I would add.
Yeah, I don't think I want to disagree with any of that. I mean, the federalism point, I think, is right, although so much law is federalized, it's going to be hard to get out of that. But I think the idea of allowing conflicts and circuits to persist is a way of doing some of that. It is, in some ways, just an accident that the legal elite, at least the Supreme Court, and the higher reaches of both parties were dominated by people who opposed segregation. Jimmy Burns was appointed by Roosevelt and, decided to do something else, but otherwise he would have been on the Supreme Court. He was a segregationist, ended up being segregationist governor of South Carolina. But, the Eisenhower appointments were made by people in the Justice Department who were committed to civil rights, and I think by that point, after 48, the Democratic Party had put down its marker as in favor of civil rights, at least in the elites. So that's why I said that, but I don't disagree.
Yeah, so obviously one of the things that's happened to the legal profession is that the whole notion of legal elite is also diversified. And I'm just sort of wondering where you see that, because obviously the diversification comes along race and gender and sexual orientation. I don't know whether it comes along gun ownership as well, but I mean the idea might be this is a phenomenon of the legal elite that changes the legal elite. I don't know which way the causal chain might be running, but most people view that as generally a good thing, right? That the legal elite is now more representative of the rest of the country, and Yeah, I was wondering where that might fit into the way you described it, because
Yeah, that's a great point. I mean, it is, I do think it is diversified along these other dimensions as well. I don't know if the members of the legal elite are themselves gun owners, they may be, but they, identify with a political coalition, which the perception is, you other guys are looking down your nose at gun owners, that's not right. That's the way in which they sympathize. I think, as I said, I thought Caroline Products established an unstable equilibrium because the legal elite at the time, you're right, it was more homogeneous. And in a country like ours, it's going to be very hard to maintain that sort of homogeneity in an elite, especially with the things that happened in the 50s and 60s, the civil rights movement, the women's movement, and so on. That it's their tendencies toward diversification of elites in a country like ours, and so in a way this was predictable. I guess I should say, I can think the way this might have taken a different path is not that the legal elite would remain united. I don't think that's, for the reasons you say, I don't think that's a plausible scenario. The plausible scenario might be a different understanding of Brown, that the alternative story is, okay, Brown, the Supreme Court's Brown using, meaning not just the decision, but the Supreme Court's efforts to push forward the civil rights movement, that was a one-off. We fought the Civil War. Lincoln had to do some things that maybe a president wouldn't otherwise do because he had to win the Civil War. We didn't wrap up the lessons of the Civil War. The Supreme Court did some things that maybe the Supreme Court shouldn't get in the habit of doing because we have to wrap that up. But that's what it was about. But that's not what happened. What happened instead was it became kind of a template. Brown that was great, and we should do more of that. And once you do more of that, then, unless you can somehow maintain cohesion on, well, now is it gays or is it religious people who are today's African Americans? Unless you can maintain cohesion on that, you're going to have these pressures. And then when it becomes partisan, those pressures get transmitted into the courts. Yeah.
On the sort of post-1937 consensus, it seems to me in addition